Okay, we're live. We're talking about the Philadelphia Eagles. We're talking about issue writing outlines and and particularly personal responsibility and, if with any luck, wills and trusts. But one thing about wills and trusts is some nice language I'm going to read is what, before I potentially don't make it to that section during this recording, I wanted to state the definition of trust, which is a trust is a fiduciary relationship with respect to property in which one person, the trustee, holds legal title to the trust property, the res, subject to enforceable equitable rights in another, the beneficiary. So again, fiduciary relationship with respect to res that the trustee holds legal title subject to enforceable equitable rights in another, the beneficiary. Can talk about whether it's an express trust or revocable trust. I took down duty of care because it's not on my cheat sheet on the wall. In administering a trust, the trustee must exercise that degree of care, skill, and caution that would be exercised by a reasonably prudent person in managing their own property. Care relates to diligence, skill to capabilities, and caution to conservatism in administering the trust. The UPIA, the Uniform Prudent Investors Act, says that a trustee must invest and manage as a reasonable investor would, considering the purpose, distribution requirements, retention, probably period is what I mean by that, tax consequences, economic conditions, liquidity needs, and income needs. And the measurement of prudence is over the entire investment strategy overall, not to each investment. And there is a duty to invest. Kind of backing up a bit, there is a duty to invest, which is to protect and preserve, protect and make productive the trust assets and to diversify. So in the essay writing approach to professional responsibility, now switching gears, the preliminary considerations is applicants should be prepared to answer questions that test the knowledge of the California rules of professional conduct, relevant sections of the California Business and Professions Code, and leading federal and state case law on the subject, in addition to the ABA model rules of professional conduct and the ABA model code of professional responsibility. Professional responsibility issues may be included in conjunction with any subject tested on the examination. State Bar of California, Committee of Bar Examiners, Office of Admissions, as revised, effective with July 2007 administration of the examination. The interrogatories that you may find on the bar exam is: what ethical violations, if any, has lawyer committed? Discuss. Answer according to ABA and California authorities. Answer according to California and ABA authorities. Answer according to both California and ABA authorities. Discuss, including distinctions, if any, between the ABA model rules and California authorities. And lastly, answer according to the California and ABA authorities to the extent that there is any difference among them. Your essay answer is IRAC dependent. Issues identified by the facts, acts, omissions, events, transaction parties, and by duties owed. Rules. No ABA rules and California rules and distinctions state accurately and fully. C. Apply rules to available facts. Consider plausible counter-arguments when possible. Add what the lawyer should have done under the circumstances to avoid or to remedy the situation. And D. Conclude whether the lawyer violated the rules or should be disciplined. So the broad issue checklist I read yesterday is the duty to the client, third parties, court, and public and profession. one of my top five. So I'm gonna lighten things up a bit. And then turn this. So I actually read page 2 and page 3 yesterday. The approach is to say that a lawyer has a duty to fill in the duty to fill in the person or thing. And examples of those can be understood in a mnemonic. Clients love fierce counsel, courts feel differently. To spell out that mnemonic, the clients are owed confidentiality, loyalty, financial responsibilities, competence. I'm going to add diligence. And the court adversaries in the legal profession are owed candor, truthfulness, fairness, dignity, and decorum. Other reasonable things are owed to third parties in the public. Interesting they say that is because I just read an NBE question where a lawyer just said something to somebody, to a purchaser or to an investor. They just said something to an investor. It doesn't say anything about having a relationship to that investor. So as far as I know, that investor's a third party. And they consider it to be intentional misrepresentation because the attorney had no reason to believe that what he said was actually going on. And I feel like you don't owe that duty to a third party unless by way of being and representing yourself as an attorney, you're representing to the entire world that every single thing that you say is honest and truthful. I think that actually wasn't a very good question for that reason, but wasn't asking about attorneys' duties to third parties. The question was trying to ask about intentional misrepresentation, which is I think it involves a duty to defraud, but that wasn't one of the elements they had in misrepresentation, which is like any statement known to be false by the person making the statement that is intended to induce reliance, and the hearer indeed relies on that statement and suffers damages. So 5 elements were in that definition of misrepresentation, intentional misrepresentation. So maybe you add intentional if I didn't already, but what I'm saying is I think the intent to defraud ought to be there, but it's just an intent to induce reliance apparently is enough in that question. So let's go to the expanded major issue checklist. Attorney's duties to the client. Part A, the duty of loyalty. The general conflicts between the lawyer and client, again, client, A, cannot be directly adverse to another client, or B, significantly produce a significant risk of material limitation based on the lawyer's personal interest or lawyer's duties to another. 1, personal interest or relationship if no significant risk of material limitation California requires or indisclosure to the client regarding personal relationships. 2, multiple clients on the same side. 3, former client. And 4, third person. So these are all applications of this rule. Specific current client conflicts. There are 6. A, business transactions, including lawyer accepting property in exchange for legal services. B, gifts. C, stake and outcome of litigation. D, sexual relationship with the client. E, using confidential information to client's disadvantage. F, limiting malpractice liability. And G, third-party payments. Third on the duty of loyalty through 7 is organization as a client. When the organization is the attorney's client, and who the attorney owes duties to within the organization, mainly is the issue. Conflicts based, so 4, conflicts based on consultations with prospective clients. 5, former government lawyer. 6, former involvement in matter as a judge or mediator. And 7, imputed disqualification. Part B of the overall attorney duties of client is the duty of silence, also known as the duty of confidentiality. The requirement is that an attorney must not reveal information relating to the representation of the client. Consider raising when you have an actual conflict of interest, even if no actual breach of confidentiality exists. And the writing approach given here is step 1, head note duty of confidentiality. Determine whether there has been a breach of the duty without taking into consideration any exceptions. If you determine there has been a breach of the duty, then separately head note the IRAC and IRAC each applicable or arguable exception to the duty. Do not discuss more than one potential exception at a time. ABA exceptions to confidentiality versus CA exceptions are tabled out here. There are several more exceptions to confidentiality under the model rules and the rules of professional conduct. So I'm going to read ABA first. To prevent reasonably certain death or substantial bodily harm is an exception to confidentiality under both model rules and RPC. Consent or implied authority. All right, so they're not the same. Actually, I read ABA, but California is stated differently. Prevent a criminal act that is likely to result in death or substantial bodily harm. Rather than preventing reasonably certain death or substantial bodily harm, this is to prevent a criminal act that is likely to result in death or substantial bodily harm. The consent or implied authority to the accept an attorney from their duty of confidentiality is the same in California as it is in the model code rules. To prevent the exception to confidentiality, prevent or rectify substantial financial harm arises under model rules, but there's no counterpart in California. Same with legal ethics advice. There's no counterpart in California. And to address conflicts of interest arising from changes to lawyers' employment or structure of firm, there's no counterpart in California. Whereas some things that are the same as malpractice defense, like a lawyer can breach the duty of confidentiality if their services are put at issue. That is the same in California. And to collect attorney's fees, if they have to, if their client isn't paying them and they have to sue the client, then some of their confidences are going to be conveyed. That's going to be the same in California. Now, exceptions, confidentiality under model rules are when the attorney is compelled by the court, ethics, rules, or law to disclose. And whereas in California, the compulsion can only be by law or court, not the ethics rules. So 2, 3, and 4 go into slightly more nuanced areas of the duty of confidentiality. So for Sarbanes-Oxley, in California, lawyers who reveal information to the SEC under the SOA can be held civilly liable or be disciplined under any inconsistent state rule. It remains to be seen whether courts will uphold the SEC's effort to trump California's strict confidentiality rule. So third, distinguish between attorney-client privilege and the duty of confidentiality when the duty of confidentiality is a major issue because exceptions to the rule. Attorney-client privilege, as evidentiary privilege, or it's an evidentiary privilege that allows a client to refuse to testify and prevent his attorney from testifying in court about confidential communications between the two of their respective agents. The two or their respective agents. So regarding the attorney-client privilege, most of this is the same between model rules in California. That one, Breaches of the duty of confidentiality are excused, let's say, when attorney discloses because of crime deterrence. I'm going to call it fraud crime exception. The way it's read here is to enable future fraud or crime, which is like said very affirmatively, but like attorney has an exception to the duty of confidentiality if their services are being used to enable future fraud or crime. I suppose that means they can disclose that to who? I don't know, but it's the same in California as the model rules. And suit between the attorney and the client, that is the same. And the exception is the same. Joint clients, the exception is the same. And to show competency or intention of the client who has attempted to dispose of property by will or inter vivos transfer. This is the same in California. And there's an additional exception in California, which is to prevent a criminal act likely to result in death or substantial bodily harm that has no exact counterpart under the model rules. So let's just move on to the duty of competence. I'm not going to talk about this joint client exception to the attorney-client privilege, because I suppose what they mean is if you are consulting with two people, that attorney-client privilege applies to them both, even though, and it's not compromised by the fact that there's another party in the room. I think that's what the exception might mean. Like the privilege is preserved, notwithstanding there's a third party who is aware of the content of the communication. So the exception would be that usually would not be protected by the privilege, being a third person in the room, but this is an exception to that. But I don't know why it would be in this table in this way. It'd be kind of separate, but perhaps that's how they want to explain it. I'm not quite sure. Like in this table, it seems to suggest when you say there's an ABA exception to the attorney-client privilege pertaining to joint clients, that will mean that if you are representing two clients, one of them wants to share a secret with you, and they do, that you must disclose it to the other client. And I guess that would be the worst case scenario in most circumstances. The, kind of pursuant to the earlier section is you talk about plausible, what the lawyer should have done in the circumstance to avoid to remedy the situation, and that would be to tell your client they can't share secrets with you without them being shared to the co-party. So it could be what the exception means in this table. So duty of competence. Duty of competence requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation in addition to the requirements below. Raised when fact pattern tells you what area of law the attorney practices, and he is representing the client in a different area of law. In California recognizes mental, emotional, and physical ability for competence. And in California, the lawyer is only subject to discipline for intentional reckless or gross negligence or repeated incompetence. And fourth, under the duty of competence, one would raise the duty of competence on its own or as one of the sub-issues below. This is within The duty to communicate or the duty of diligence. Note that California has no the rules of professional conduct would not be disciplining a breach of the duty of diligence unless it was intentional, reckless, or gross negligence or repeated incompetence. So that likewise would be the case with competence and with diligence then. And there's a duty to withdraw from representation under the duty of competence, and there's mandatory withdrawal and permissive withdrawal. I don't know if I will put that there. Did I skip a page? Okay. So the duty of financial integrity or other financial issues, attorney fees, A and B. A, fees generally dash amount is what we're going to talk about. And they have to be reasonable under the model rules, but in California, the fees cannot be unconscionably high. And secondarily, in the attorney fee section, agreements with non-contingency cases must include how the fee is calculated, what services are covered, and the lawyer and client's duties. California requires a writing unless the fee is under $1,000. It's a corporate client, and the fee, the representation is for routine services for regular client or emergency or impracticability. One of these two rule sets allow you to not put the fee in writing if the client has requested that it's not put in writing, but I guess that's rare. So contingency cases, fee cases, these must be written both under model rules and RPC, signed by the client, and contain a contingency fee percentage, expenses that will be deducted, and when the percentage is deducted. In California, there's further requirements over contingency fee cases that would require the attorney to include how the work not covered by the contingency fee will be paid, and that the lawyer's fees are negotiable. And contingency fees are not allowed in criminal or domestic relation cases. That is true under the model rules in California. Fee splitting between lawyers and non-lawyers is an issue. It doesn't say how to hold on it. Among lawyers, this is permissible if it's been approved by the client and it's reasonable for the actual division of work, not like a referral fee. And non-lawyers, you can't fee split with non-lawyers in any place in the U.S. Payments for or in any unusual arrangement, except for some really rare circumstances, like when someone dies and you're giving their estate, their earned income. And then payments for recommendations that you can't likely do. It doesn't really give anything else beyond that, just to be aware that could be an issue that you would have to discuss. Advancement of court costs and personal loans to clients. That often is permissible, but it has to be well disclosed. There's some limitations, like making promises about paying that back. So third-party payments, also a duty of loyalty, conflict of interest issue for third-party payments, which I'm guessing by that they mean that another third party is paying for the client's services. So the important thing to note is the duty of loyalty belongs to the client, not the person paying for the services. And there is a duty to safeguard client trust account and a duty not to commingle finances with the client trust account. So Other duties of the client is the scope of representation. Whenever the fact pattern mentions a settlement agreement or plea deal, raise both duty to communicate and scope of representation, and not to assist the client in criminal or fraudulent conduct. Those are the other duties, or just ancillary topics that weren't covered in the other broader sections. There's 2 more sections here, or three. Attorneys' duties to third parties, which includes the duty to accept representation at times, and the special duty of prosecutors to disclose exculpatory information. And then the duty to opposing parties in litigation. This includes but is not limited to a duty to produce evidence, a duty not to destroy or tamper with evidence, and a duty to return documents sent inadvertently, like privileged material. When California requires that you stop reading it once you understand that it was sent in error. And then the attorneys, you also need to call that information back if you've accidentally or inadvertently shared it. The duty, the opposing party who sent it in error has informed you that it was not their intention to share that information. I'm now blending a little bit of Civ Pro in here. So the attorney owes duties to the court. The duty of candor includes but is not limited to a duty to not knowingly offer false evidence, or a duty to not further perjury. There's a duty of honesty and a duty to witnesses and jurors. So I think in the duty of honesty, have to cite the law accurately and correct in misstatements. And if you're the only person that knows about law that doesn't support your client's argument, you still need to disclose that. Can't intentionally hide it. You can't get away with hiding it. So the attorney's duty to the profession. A, the duty to avoid unauthorized practice of law. 1, this includes the duty to avoid assisting another in the unauthorized practice of law. In California, there are specific rules regarding the employment of disparate employers. B, the duty to avoid false or misleading advertisements. And C, the duty not to improperly solicit clients. So you really can't do so face-to-face. Have to, or on the phone. So I'm going to navigate over to wills and trusts and see just how long this outline is going to be. Looks like in totality, it's going to be 8 pages of discussing what's the best order of writing essays, about 3.5 pages each. I'm just going to read the broad titles right now. In the essay writing approach to wills, the first large subsection is testate estates, the execution of wills, and the revocation of wills. So I'm just going to read formation, this first section being the most important. Proper execution of wills but require an attestation, which there's 3 main issues with attestations. Is that the signature of the testator is required, plus 2 witnesses present at the same time. They may not be interested with, in the will. They not have an interest in the will. And harmless errors, at least in California, harmless error doctrines observed for substantial compliance with the section. Holographic wills, on the other hand, require signature and material provisions in T's handwriting. Testamentary capacity is required for them both. Holographic wills and valid wills, they cannot be influenced they cannot be subject to undue influence or insane delusion or fraud. And there's a conflict of laws section in here. So, I mean, another requirement of a will is that it needs to actually give a grant. It can't just like be a negative will where it's like I disinherit so and so and I don't like that's period, that's it. Testamentary capacity requires that a testator know with reasonable surety like the bounds of their property and the object of their bounty, among several other things. So this is a very high-level outline. So the revocation of wills by subsequent will, physical acts, operation of law. There is a dependent relative revocation section. They've been placing a high emphasis on this, which is shocking because it's much longer than the formation section, stating under the DRR that cancels a revocation applies where a testator revokes his will on the mistaken belief that another disposition would be effective, and before the mistake, the testator probably would not have revoked their will. This has the effect of canceling a revocation based on mistaken assumption of fact or law. I'm not reading the examples, but I find it shocking that half of the page has to do with DRR, and they basically put nothing in there about formation, which is like the most important. Look it up. Notes here. Most important thing. How do you form a will? I mean, I'm not saying I don't know it by heart. I just would like it to be confirmed by actual rule of law. Wills is the last section here. It's pertaining only to California. I'm just going to read the section title of formation. Or not. I find it rather ridiculous about how they lay this out. Somewhere between page 16 and 20 within wills, which I don't actually. Okay. Execution of attested wills. A will must be in writing, signed by the testator, joint presence of at least 2 uninterested witnesses. They must sign the will during the testator's lifetime, and the witnesses must understand that the instrument being witnessed is the testator will. So that's like the execution of tested wills. What I've written here is writing, legal capacity. You have to be over 18 and of sound mind. There has to be testamentary intent, present intent. Testator has to sign their own will or have asked someone to sign in their presence. Directed someone to sign, right? Testator's name, or some other person in the testator's presence, and by the testator's direction, or a conservator placed there by the court. What's codicil? So a holographic will is one that is handwritten and signed by the testator but has no witnesses. In the majority of states, including California, holographic wills and codicils are recognized. Dates are nice, not required. Requires testamentary capacity, testator signature, testamentary intent. Can be on commercially printed forms. The material provisions have to be in the testator's handwriting. Interlineations. Most states recognize holographic wills give effect to handwritten changes such as substituting beneficiaries made by the testator after the holographic will is completed. So I'm going to go back to just reading the headings again. Components of wills, integration, which includes integration and republication of the codicil and the corporation by reference and acts of independent significance. Okay, all of this is really important. At least those three components of wills are incredibly important. So for integration, papers present at execution of the will with intent that they're integrated. Republication by codicil the codicil can revive. I'm going to say revive the will at the date of the codicil. And then incorporation by reference requires a writing and is in existence at the execution. The will shows intent to incorporate, and the writing is sufficiently described in the will for acts of independent significance. Identify beneficiaries or property by lifetime acts with independent motive and interpretation of wills. There's a lot here. I would think construction is what they mean by that, but they're talking about admission of extrinsic evidence, classifying the gift into specific, demonstrating general and residuary, talking to abatement, and redemption, and lapse. Intestate succession is something to know about the share of the surviving spouse, share not passing the surviving spouse, issue parents issue, etc. In California, it is not SERPs. It's like rights by representation. And special problems with adoption, stepchildren, and advancements, disclaimers, simultaneous death, rights of surviving spouse and children, speaking to omitted spouses and omitted children. This is tested a lot. So an omitted spouse is a spouse omitted from premarital will, receives intestate share unless it was an intentional omission and they were provided for outside the will, or waived their rights, invalid agreement, and the spouse was the decedent's care custodian. Their marriage began while the spouse provided services, or within 90 days after services were last provided. The decedent died less than 6 months after the marriage began. Omitted children, the definition of which is one from pre-birth, is omitted from pre-birth testamentary instruments, will and irrevocable trust, clearly written before the child was born, or they will receive the intestate share if unless the omission was intentional. Other children. That's enough to say about that. Bars of succession is homicide, elder abuse, and no contest clause. I didn't talk about revival. I kind of skipped it, but I'm going into trusts now. Requirements of an express private trust. The settlor with capacity and present intent to create a trust must intend trust to take effect immediately, must express intent by words or conduct while the settlor owns the property. Precatory expressions which hope or suggestions result in inference that no trust was intended, but inference may be overcome by other evidence. Trustee, res, beneficiaries, valid trust purpose, and the formalities for an inter vivos trust must require that the trust is created during the settlor's life, whereas testamentary trust, it may be the trust may be created by the settlor's will. Pour over provision. Charitable and honorary trust is the next big subsection. Transfer of beneficiaries' interests and creditors' rights. This talks to spendthrift trusts and discretionary trusts, support trusts, and like alienability. Subpart 4, modification, termination of trust. This is where you'll talk about revocation. Beneficiaries can terminate or modify a trust if all beneficiaries consent. Watch for remote unborn beneficiaries. I don't know why, because that was overcome, if I'm not mistaken. I don't know. Maybe there's split authorities on this because I've heard both things. Here it says it will not interfere if so a trust may be terminated or modified if it will not interfere with the material purpose from Claflin. And examples of purposes precluding termination is distribution of specific age, preserving property for remaindermen, or protecting beneficiary from their own poor judgment. Joinder of a settler waives material purpose, and spendthrift trust cannot be terminated without the settler's consent. The court can terminate a trust if its purposes are illegal or impossible, or a change of circumstance makes compliance incompatible with the trust's purpose. Trust administration, trustee powers and duties. Let's talk about the powers to sell and lease unless limited by the trust instrument, incur expenses necessary and ordinary management expenses, for instance. Power to improve property is usually not inferred, and power to borrow money must be granted in the trust instrument. Trust duties is care, loyalty, no self-dealing. Duty to separate trust property. Earmark is another way to say that. Duty to perform personally. Duty to preserve property and make it productive. Those investments we were talking about. Trustee liability. And I might read those because no question is going to ask. No question that enters into trust duties, which is highly tested, is going to go there without talking about the remedies. So a trustee is liable to beneficiaries for breach of trust, and they will bring a surcharge action. They're liable for losses from one breach, but may not be offset against gains from another. So losses from one breach may not be offset by gains from another breach. Defenses, latches or express or implied consent to the breach by beneficiaries. Exculpatory clauses relieving the trustee of all liability or liability for bad faith, intentional breach, or recklessness are void. Okay, probably just, entirely void, just void when there's bad faith, intentional breaches, or reckless. Maybe not recklessness. I don't know. I want to make that up. UPAIA sets forth how to allocate receipts and expenses and income on trust assets. Will substitutes is what a trust is. So they talk about revocable trusts, life insurance trusts, Totten trust bank accounts, and resulting constructive trusts are discussed. So I'm going to actually end it there without going into much more of those sections. Let's just have to do that in your own study of those concepts. Where am I recording?